Incoterms are the commonly used trade terms relating to international sales arrangements published by the International Chamber of Commerce. Essentially, they set out buyer and seller responsibilities and aim to avoid misunderstandings which may arise during the course of delivery of goods. If your company trades on an international basis or either ships or receives shipments of goods from an overseas market, then you should be aware of these terms and their application. The main aim of Incoterms is to avoid any misunderstandings which may arise between different trading practices in different countries. For example, DDP, delivered duty paid, may mean an entirely different thing to a US company than it does for a UK company. However, it is important to ensure that the Incoterms are effectively incorporated, and this will be discussed later. It should be noted that certain countries stipulate which specific Incoterms must be used. Other countries specify which Incoterms are preferred. In order to consider how this affects you, you must look to the country of the buyer. The basic aim of Incoterms is to govern the delivery of goods between parties engaging in international trade. Each Incoterm will clarify how the functions, risks and costs are to be split between the parties. Incoterms 2010 came into force on the 1st of January 2011. This brought about significant changes when compared with Incoterms 2000. The main changes are: there are now 11 rules rather than 13. The rules are split into two distinct classes relating to the mode of transport used. Changes now deal with cargo security, and they are generally regarded as being more user-friendly and reflect modern trade language. Notwithstanding the changes that have been made to the Incoterms in their most recent incarnation, a number of the terms have remained largely the same. The first group, often referred to as the E-terms, applies to a situation where the seller makes available the goods at its premises for the buyer to collect. It represents the minimum obligation for the seller. Whilst it is the only one of this category, it is perhaps the most well-known, EXW. All three current Incoterms falling under F, namely free carrier, FCA, free alongside ship, FAS, and free on board, FOB, apply to situations where the seller must deliver the goods to a carrier appointed by the buyer. The seller will arrange and pay for delivering goods to the carrier, but the buyer pays for the carriage from that point forwards. The FCA Incoterm can be used within any mode of transport, whilst FAS and FOB are used only for the sea or inland waterway transporting. The C terms state that the seller has to contract for carriage, but does not assume the risk of loss or damage to the goods or any additional cost due to events occurring after shipment. Of the four Incoterms falling under this category, cost and freight, CFR, and cost insurance and freight, CIF, can only be used for goods shipped by sea or inland waterways, whereas carriage paid to, CPT, and carriage and insurance paid to, CIP, can be used for any form of transport. The main change brought about by Incoterms 2010 relates to the new rules for delivery. DAT, delivered at terminal, and DAP, delivered at place, are the new rules which replace DAF, DES, DEQ, and DDU. DDP, delivered duty paid, is the only Incoterm which remains unchanged since the new publication. The following rules of delivery apply regardless of the mode of transport used. DAT. Delivery takes place when the seller puts the goods at the disposal of the buyer at a named terminal. The seller bears all risk involved in bringing goods to and unloading them at the terminal, including clearing goods for export. DAP. Delivered at place means that delivery takes place when the goods are placed at the disposal of the buyer at a named place ready for unloading. That is, the buyer has to unload. If using this Incoterm, a seller should ensure that any contracts for carriage reflect this term. If the seller inadvertently pays its carrier for unloading, it will not be entitled to recover this cost from the buyer unless the parties expressly agree that this is to be the case. Where under Incoterms 2000, DAF, DES or DDU were used, DAP should now be used. Where DEQ was previously used, DAT should now be used. Events of the past 10 years have led to security being tightened in all walks of life. Obligatory security checks have now been imposed in many countries, and both sellers and buyers are now required to provide a lot more information in order to obtain export and importation clearance. Incoterms 2010 imposes an obligation on both parties to provide the other party with the information that they need in order for them to obtain these clearances. Incoterms 2010 take into account the amendments made to the Institute of Cargo clauses with regards to those rules which require a party to obtain insurance, that is, CIF and CIP. Note, however, that under these rules, the seller is only obliged to provide a minimum insurance cover in accordance with Clause C of the Institute of Cargo clauses. As this is a low level of insurance, buyers should perhaps consider requiring a seller to obtain a higher level of cover. Incoterms 2010 recognise that there has been a change in the way that parties do business together, especially with regards to the use of electronic documents. The rules now state that a document may be replaced with an electronic communication where the parties agree or where it is customary to do so. Essentially, electronic communications have now been given the same effect as paper. Where commodities are the subject of a sale, cargo may be sold a number of times during the course of transit, down a string. In this case, a seller in the middle of the process will not physically ship the goods as they have already been shipped. To clarify this position, Incoterms 2010 includes an obligation to procure goods shipped as an alternative to the obligation to ship. In addition to the above, Incoterms 2010 for the first time recognises that the rule should be capable of use in both international and domestic trade scenarios. As a result of this, the rules clearly state in a number of places that the obligations to comply with import and export formalities only exist where applicable. In deciding which Incoterms suit your requirements, you need to consider certain key factors such as the form of transport to be used and who is to bear the risk and cost of delivery. It is also important to understand whether there are any jurisdictional requirements which will govern the terms to be used. There are many guides and summaries of the Incoterm rules available from reputable websites. However, it is worth noting that these are just summaries. Each Incoterm contains a number of subclauses which details each party's roles and responsibilities. As such, whilst these summaries are of use, there is no substitute to reading and understanding the Incoterms in full. The main thing to remember to ensure that you have the protection of Incoterms and that they are incorporated is that you must reference them. So you should actually reference Incoterms 2010. A failure to reference the terms or the correct version of them could lead to a dispute as to which version is intended, or indeed if Incoterms are intended to apply at all. There are two ways to incorporate Incoterms: by including some wording as a general proviso in the contract to state that it is subject to Incoterms 2010, or by specific reference in the delivery provisions. It is important to note that you should also reference the relevant edition of the Incoterms in all paperwork linked to the contract, such as invoices, statements or delivery notes. Other important points to note when incorporating the Incoterms into a contract are that you should always reference the delivery location. For example, if you are in a situation where it is delivery duty paid, so one where the seller does everything, and you are delivering to a warehouse in Germany, you would reference in the contract to DDP, Delivered Duty Paid, Frankfurt Schmidt GmbH Warehouse 4, Incoterms 2010. In another example, if you are free carrying to Kuala Lumpur, you would reference FCA, Free Carrier, Kuala Lumpur, Incoterms 2010. A final point is to ensure that any contract always states which country's legal system will be used in the case of a dispute. The Incoterms will then provide the legal backbone to settling such a dispute.